Part 3 of the TOLA video is here, as promised. So, in part 1, we covered the policy context. The argument I made was that a lot of amendments to surveillance law was actually about maintaining the current balance between privacy and security. New technology means in Australia that authorities need new powers to make it clear what is lawful interception, rather than leaving it up to agencies to mutate existing powers, as happens in other countries. In part 2, I demonstrated this point by giving an overview of the individual components of the TOLA, highlighting that the two most controversial parts of TOLA were parts that did not actually permit additional access to private messages. So here we are in part 3. In the final part, I want to bring the lens back out to the landscape of national security law more generally. And I'm going to show you how we know that we can trust authorities to do the right thing and verify that they are doing the right thing. Let's look at the way media generally frames legislative debates. Now, as an example, I'll use Denham-Sadler's report in Innovation Australia on the online safety bill. I don't mean to single him out specifically for criticism. It's actually the opposite. I've used this article because it is stock standard for legal journalism rather than being actively terrible. So the article is 891 words long, and only 72 of those words are actually about the content of the bill. Those words there. The online safety bill extends the online content takedown scheme to Australian adults, allowing for the issuing of removal notices for content deemed to be rated R18 plus and higher, and to order the sites and apps to be blocked if they don't comply. Communications Minister Paul Fletcher has said that the bill gives new protections for Australian adults subjected to seriously harmful cyber abuse and widens the powers of the e-Safety Commissioner. Now that is not enough for the ordinary reader to understand the content of the bill. The rest of the article is merely about the theatre of how the legislation has progressed through Parliament. More than half of the piece, 595 words, relates to non-specific criticism of the bill, where the reader, without reviewing the legislation themselves, cannot form a view about the accuracy of those complaints. The reader simply has to trust whichever person is making the claim. Now, in fairness to Mr. Sadler, at least he doesn't do the usual journalistic practice of getting an expert legal commentator to make similarly vague, non-specific criticisms of the legislation. The role of the expert should be so that the ordinary person can make an informed choice about how they feel about a complex policy or issue. It is generally not the case that legislation falls out of the air. It is more common for there to be inconsistent speed, accelerations and decelerations in the process. So here's the defamation law reform. The original discussion paper was sitting around for years prior to it landing back on the agenda of the Council of Attorneys General. Then things started moving again at a faster pace. Very little was invented or imagined after the original discussion paper. The same is true of national security law. Not a lot just drops out of the sky, but following debates can be difficult. In the rest of this video, I'll show you how the oversight structure works so that you could, if you wanted, follow national security legislation policy debates. The overall message of this video is that when you read articles about law reform, suspend judgment until you're satisfied that you can answer these 3 questions. What is the current... Oh, sorry, that's the previous slide. When you read it, ask yourself these 3 questions. 1, what is the current state of the law? 2, what is being proposed in the new law? And 3, what are the best arguments in favour and against the proposed law? Now, if you can't answer those 3 questions from the media, you are going to have to look elsewhere. Let's start with the big one. The Parliamentary Joint Committee on Intelligence and Security, PJCIS. I introduced the PJCIS in the first video to explain part of how TOLA became law. What I didn't do was show how much the committee covers or some of its more useful functions for public debate. Now, the PJCIS is the contemporary manifestation of a parliamentary committee that was established back in the 1980s. There were ongoing questions about precisely how to structure Australia's intelligence community in a way that upheld community expectations and norms. I won't get into this too deeply. It involves some amazing stories and one of my favourite High Court cases, but this is the part that's relevant. There were 2 royal commissions into the intelligence community. Both were led by the same commissioner, Justice Robert Hope. The second royal commission is the important one for this video. The government asks the commission, hey, other countries have parliamentary oversight of their intelligence agencies. Should Australia? Now, Justice Hope's answer is surprising. No. In Justice Hope's view, it was neither necessary nor appropriate for there to be parliamentary oversight of the intelligence community. Now, despite this, a parliamentary committee is established with a very specific focus: oversight of the administration and finances of some intelligence organisations. The philosophical position was that oversight should not purely be a function of the executive branch of government, but should also include oversight by elected representatives of the public a bit more widely, by which we mean Parliament. It's successful, and its success results in the broadening of its scope. Today, administration and finances occupies relatively little of its time. Its major function today is pre-enactment scrutiny of national security legislation. What does this mean? Pre-enactment scrutiny means that it looks at bills prior to them becoming acts passed by both houses of Parliament. If you're trying to get your head around the policy dimension of legislation, these reports by PJCIS are invaluable. This pre-enactment scrutiny not only involves producing a report, which it does, but it also involves seeking submissions from the wider public and holding hearings. The submissions are of varying qualities, so caveat emptor. PJCIS also undertakes policy inquiries. So they'll do inquiries into issues about national security law and policy. These can be a bit hit and miss. Sometimes they are overtly partisan and so of limited quality. Where the inquiry is intellectually serious, you tend to get pretty good consensus reports. Another caveat: PJCIS tends to be the domain of the Coalition and the ALP. They have had some independence on the committee in the past, but this is unusual. Now, to the best of my knowledge, there have never had a Greens member. If you are a rusted-on Green supporter, you might be unsatisfied by the lack of representation here. But PJCIS is not the only beam in the framework. The PJCIS was for pre-enactment review. For post-enactment review, we turn to a relative newcomer, the Independent National Security Legislation Monitor, INSLM. The role of the INSLM is to look at how the legislation is being used and to assess the appropriateness of that use. Imagine that there is a piece of legislation where the intent was clearly that ASIO could read the thoughts of everybody wearing a blue hat. Now, you might think, hey, the definition of blue hat is vague and subjective. My blue might not necessarily be your blue. Does hat include helmets, for example? And what you would want is some reassurance that the spirit of the legislation was being upheld. Depending on the power, maybe it's important that blue means those colours over which there is no reasonable disagreement is blue. No blue, greens or purples, for example. Or maybe the power is such that you're willing to accept some fuzziness, but want ASIO to be reasonable about what counts as blue. So this is the role that INSLM plays. It is always a senior lawyer. The first INSLM was the famous Brett Walker. And they have an eye on the legislation and complete access to the operational details. If legislation needs to be tightened up, if powers are being used incorrectly, or, and this is important, if powers are inadequate for real or emerging threats, the INSLM is the one who will know. Okay, mark opinion time here. Our INSLM was based on the UK model, the Independent Reviewer of Terrorism Legislation, IRTL. We have had some IRTLs who were real raconteurs who actively wanted to participate in public debate and engage the wider community in policy discussions. Here is David Anderson, a previous IRTL who not only wrote beautifully but genuinely attempted to contribute constructively to public debate. I've missed where I am in my script, through thought-provoking reports. It would not be an accurate description of our INSLM that these reports are highly readable. They are, instead, really very, very dry. They're also largely ignored. Kevin Rudd appointed the first INSLM, Brett Walker, and then did his level best to ignore absolutely everything that he said. When Tony Abbott became Prime Minister, there was a lot of doubt about whether or not the position would continue. This is not a good sign for the INSLM. In my view, opinion time, if we appointed a vibrant, dynamic, and very public INSLM, it would weld the position into the oversight infrastructure and better fulfill its role of informing public debate. Right, next. The Inspector General of Intelligence and Security, IGIS. This is the watchdog function. It's an extremely powerful position that, like INSLM, has powers to access classified information. Now, unlike INSLM, whose focus is on legislation, IGIS is looking at the functions of the agency to ensure that they are lawful and proper. Are agencies behaving lawfully? Are agencies behaving in a way that is consistent with community standards? Are agencies behaving in a way that is consistent with human rights? Establishing IGIS was a recommendation of the second Royal Commission referenced earlier. It works really well for two reasons. First, it is effectively a standing Royal Commission into the key intelligence agencies. It can compel people to answer questions, take sworn evidence, and physically enter agencies. Second, IGIS is very well established into the oversight infrastructure, it's highly respected, and there are strong cultural norms within the intelligence agencies about being open and frank with the IGIS. In fact, intelligence agencies have a strong incentive to make IGIS work. Having a strong independent watchdog with the powers of a Royal Commission that operates on business as usual terms is far easier to manage and less disruptive than to have a series of politically motivated Royal Commissions having bespoke operating procedures. Again, I think IGIS could do more to inform public debate, but it is more of a balancing act here. So, IGIS, INSLM and PJCIS have all produced an incredible array of materials about TOLA. Given that it has produced so much material of such high quality, the question then remains, why is there so much mythology about the Act? If they're so good, why is the TOLA debate so bad? This gets me back to the example of Denon Sadler's piece earlier. At the time TOLA was going through, there was a lot of very bold, dramatic claims made in the media, both by advocates and by opponents of the bill. What was more difficult was finding anyone who could explain the TOLA in relatively neutral terms, or at the very least, in terms that invited people to form their own views, armed with answers to those three questions from earlier. What was the current state of the law? What does the amendment propose? And what are the best arguments either way? Definitely online, the main rhetoric from critics was that they simply did not believe the claims of the intelligence agencies. But you didn't need to believe them. You had independent oversight bodies who were able to look at the evidence and verify the claims being made. I don't think that the PJCIS, INSLM or IGIS are perfect. There are a lot of things that I would amend to make them more effective. Further, I think that there are some really interesting emergent properties that developed organically that we could encourage by tweaking the way that they function. But as a source of information, they are orders of magnitude more reliable and informative than a lot of the performative theatrical debate that we get in public. So, that is it for TOLA. Forgive the lateness of the final entry, July was an absolute mess. Subscribe to get a notification when the next video goes live, which I definitely hope will be sooner than a month from now. Some really interesting legal news has just dropped, including the new defamation law provisions, an inquiry into an amendment to the Constitution, and some interesting new cases. Thoughts and prayers for me. If you want to argue with me further about all of this, head on over to Twitter @LegalReckoning, like and subscribe, and I will see you next time. Bye-bye.